So the choice for me is very stark.
Yeah.
Either people are allowed to decide for themselves or the government decides for them. And you do not want the government deciding that for you.
I am a husband, a father, a lawyer, a Christian, and a proud Canadian. I started this series because it was clear that our nation needs truth. Not just another biased narrative, but real information of substance. We need access to facts and the freedom to think for ourselves. I'm Leighton Grey, and this is Grey Matter.
Hello, everyone. Welcome to another episode of Grey Matter. Well, when they do market studies and they ask people who hire lawyers what their main complaints are, it might surprise you to learn that the main one that they always get is that the lawyer talks over their head, that they don't understand what's going on, and that lawyers use big words. Well, we have today on the show one of Canada's top legal scholars, and one of the things that he's so great at is taking complex legal ideas and making them really readily understandable in a way that that makes it clear really what's going on in the law. He's also a very astute observer of what's going on in the Canadian polity, and his name is Bruce Pardy, Professor Bruce Pardy. Thanks for being on the show today, Bruce.
Leighton, thank you very much. Always nice to be with you.
I've been looking forward to this conversation. There's so many great topics that we can dive into. But before we do that, as we always do, we're going to start with some framing aphorisms. The first one is from Aristotle, who wrote many things. One of them was, law is order and good law is good order. Be great if the Trudeau Liberals would follow that one a little bit. The next one is from Thomas Jefferson, who wrote, when injustice becomes law, resistance becomes duty. Next, from St. Augustine, who wrote, it seems to me that an unjust law is no law at all. And finally, from Jeremy Bentham, the great English philosopher, the power of the lawyer is in the uncertainty of the law. Who do we have on the show today? Well, Professor Pardy is a classically liberal legal academic for whom equal application of the law, negative rights, private property, limited government, and separation of powers are foundational to the Canadian and Western legal tradition. He's a critic of legal progressivism, social justice, and the discretionary administrative state. He has written on a range of pressing legal subjects at the front lines of the culture war inside the law, including environmental governance, climate change, energy policy, human rights and freedoms, professional and university governance, property and tort theory, free markets, and the rule of law. He's taught at law schools in Canada, the US, and New Zealand, and practiced civil litigation at a top Canadian firm, Borden Ladner Gervais LLP in Toronto. He's also served as an adjudicator and mediator on the Ontario Environmental Review Tribunal and has published and commented widely in traditional and online media. He serves as senior fellow at the Fraser Institute and helped to birth the Runnymede Society, a branch of the Canadian Constitution Foundation. And he spearheaded resistance to an ultimate repeal of the Law Society of Ontario's Statement of Principles, SOP policy, that required Ontario lawyers to attest to their ideological purity to maintain their license to practice. I don't know of any lawyer who's ideologically pure. I'd like to meet that lawyer. He's also one of the co-creators of the Free North Declaration, a public petition and movement to protect civil liberties in Canada from COVID-19 irrationality and overreach. And he speaks broadly about that and related topics. He's also, understand he's on leave from Queen's Law to serve as the executive director of Rights Probe, a division of the Energy Probe Research Foundation, which is one of Canada's leading public policy and governance think tanks. So, Bruce, welcome to the program. Very exciting to have you on. First of all, for those who don't know, I wonder if you could tell us a little bit about your work at Rights Probe.
Yeah, by all means. So we're a very small law and liberty think tank. And the mandate that we've given ourselves is to try to explain the ways in which the law works and how the law works and how it doesn't. And the latter is becoming more and more apparent to more people, I think.
Mm-hmm.
It started to become apparent to a lot of people for the first time during COVID. Mm-hmm. But the thing about that the curtain being pulled back during COVID is that it was pulled back on a whole lot of things that were already there. they just became a whole lot worse, a whole lot more acute during COVID. And so what we try to do at Rights Probe is to dive into the ways in which we think the law is supposed to work, and then the gap between that and the way it actually does work, and to try to bring people up to speed on the ways in which they've put faith in the legal system, not always in a way that has come to work out. And it's a very sobering time for this kind of discussion. It's long past due, and one of the silver linings of COVID, perhaps, has been that more people are having this kind of conversation. But in many ways, the legal ground has been shifting beneath our feet for quite a while. But now you can feel it move.
I've had this sense, like you, for a long time, that sort of the sands have been shifting. But it's very striking. Some of the things that we're seeing are really, I couldn't have imagined. And one example you mentioned about COVID-19. One thing I'd like to ask you about is our Supreme Court of Canada, as you know, has this very special role of clarifying the law nationally and dealing with really important legal subjects, societal subjects that affect most Canadians, perhaps all Canadians. But they have persistently and steadfastly refused to hear any case involving COVID-19, even appeals from the British Columbia Court of Appeal and Manitoba Court of Appeal over things like lockdown restrictions, which affected millions of people in those provinces, and indeed it affected all Canadians. So what is your take? Why is the Supreme Court of Canada so reluctant to hear any case involving an assessment of COVID-19?
That's a really good question. To tell you the truth, I'm not surprised that they have turned these cases down. As we both know, the legal experience during COVID was not pretty. There were several cases that were brought that should have been winners, should have found charter violations, and now, mind you, not all of them. Not all the cases were sound, but many of them were. And the court steadfastly refused to go there. And I have the sense, and it's not based upon very much. Of course, they don't, the Supreme Court of Canada doesn't give reasons when they turn down a leave to appeal.
Yeah.
So we're left with a lot of guessing. But my theory would be that they just don't want to touch it. Some of the things that courts did during this period were very questionable. The reasoning was questionable. The conclusions didn't make sense. And if you're the highest court and you're aware that maybe things didn't fit together extremely well, but you don't want to change the outcome, then the safest thing for you to do is just leave it alone. And not wear it yourself, not get into the weeds of it. Just, the thing is over. It's passed us by. The holdings were what they were. What good will come of us wading in there and trying to uphold what happened and yet having to correct maybe what the mistakes were? There's just nothing in it. Let's just not do that.
I totally agree. I have the same sense that it's a case of it's your baby, you rock it, where the Supreme Court of Canada is saying, look, governments, you really messed up. You made some really bad mistakes. They're not saying it without saying it. And as you say, they don't want to come in and sort of try and make sense of this, try and make chicken salad out of, chicken, what.
Right.
But the problem is COVID's not going away, is it? I mean, we've got a government in Nova Scotia right now that is about to pass a new bill that astonishingly is going to give the government, provincial government, entitlement to have access to everyone's private medical records. And this seems to be in our opening, you were very unabashedly say you're against progressivism. This seems to be a progression from COVID laws. Would you agree with that assessment?
Oh yeah. Oh,
do you have
no
some
question.
concerns about that law?
Oh, absolutely. So so you and I and others said this from the beginning. which was that COVID itself would go away, but we'd be left with the legacy, the legal legacy, the governance legacy that the thresholds were breached. And now that they're breached, we're not going back to where we were. Now that's the new standard. And so the governments are carrying on as though COVID or COVID-like scenarios are still a thing, even though COVID itself has faded into the background.
Mm-hmm.
And yeah, so the liberties, and I use that word reluctantly, I suppose, the liberties that the governments are taking now with matters that before would have seemed to be a little outrageous, now people are maybe not noticing so much. So let's just describe what's at stake here. Again, in Nova Scotia, and Nova Scotia, by the way, is not the only place that this is under consideration. But Nova Scotia is considering allowing the government to access your personal health records. Why? Well, research or tracking of population trends or who knows. But the idea that the government should insist upon having your personal information, I'm not sure that before COVID, people wouldn't have reacted like, well, that's not right. Now we'll see. Because part of the COVID experience has been to condition people to think that this kind of oversight is necessary in order to protect the population from, all the bad things that might be coming down the pike. But it's a reflection, to me, of the breach of the threshold, or the thresholds, plural, that we had before COVID. Now we're in a different place.
When I was reading about this new law, it reminded me of a case involving a judge whose name is Brinton. You probably know about this. I believe she's in New Brunswick, and she was on maternity leave, and she's now resigned, and she's suing over this. She's suing the chief judge of the court. But in her pleading, she actually says that she was on maternity leave. She would not reveal her vaccination status. This is during the height of COVID. And that the chief judge of the court actually contacted her doctor and said, I'm the chief judge. You have to tell me whether or not this person, the Judge Brinton, is vaccinated. And so it's sort of, when I connect those two stories, it seems to support what you're saying about this sort of degeneration, this whittling away of our fundamental legal rights, not just the ones in the charter, but even things like our right to privacy, which I guess is constitutionally protected. But there's this time-honored understanding that in statute and really in tradition that the relationship between a patient and a doctor is protected. It's sacrosanct, and it causes me to have concern about comparable relationships like solicitor-client privilege between a lawyer and a client. Do you share my concern about this?
Oh, absolutely. In a way, one could interpret this as just one more indication, one more step in a very long path from a trend that's been in our law for quite a long time. Now, nothing happens suddenly. It's very slow, but this really is the ascension of the idea that public interest trumps individual rights.
Yeah.
That because the government might need your information, or for that matter, the chief judge might need to know the provincial judge's information in order to protect the group, means that, I'm sorry, I mean, yeah, you have individual private information, but really we can't leave that in your hands because we really need it. Necessity, is the refuge of tyrants. It's always been the case.
Yeah.
But the rationale of public interest, even when it's really not acute, it's just really not acute. It'd be bad enough if it was acute. I'm not saying acute public interest is sufficient, but when the public interest is even not that acute, it is still providing the rationale for insisting upon the release of that which should be and once was regarded to be personal and private.
This reminds me of a quotation I saw the other day. This is from former President Eisenhower. He said, "If you want total security, go to a prison. there you're fed, clothed, given medical care, and so on. The only thing lacking is freedom."
Yes,
But,
that's right. And you'll
yeah.
and you'll also be very well in theory anyway. You'll also be very safe in prison. Maybe not from not for your fellow inmates, but certainly from all the dangers from outside.
Yeah.
So it's still not a place you want to be.
No, but it sort of begs the question of, is our society becoming prison-like? Is that sort of where we're going? Another example of this that's happening right now in Canada, I know that being in Ontario, this is something that you probably know a lot about. Several years ago, Dr. Jordan Peterson rose to public prominence when he spoke out about compelled speech, forcing people in Ontario to use preferred pronouns when addressing somebody who identifies as non-binary or the like. And he warned at the time, and I watched this interview recently, and it was so prescient. He warned at the time that this was the beginning of a slippery slope. And now here we are in 2024, and we have the Minister of Justice introducing a bill C-63, which describes online harms, but actually is hate speech laws. And we've seen how these have worked in places like Australia and Great Britain, and it's truly horrifying. Do you want to talk about this a little bit and why Canadians should be concerned about this legislation?
Yeah, sure. This is yet another one of the Trudeau government's horrible ideas. It may be the worst one of all. I don't know, but C-63, and you mentioned other jurisdictions. It's happening, as you say, but also in still other jurisdictions. I mean, Scotland sounds like a bad place now for this kind of thing. Ireland, maybe Germany. It's funny how it's all happening at the same time. But in any respect, C-63 is, if you like, the return of the old Section 13 of the Canadian Human Rights Act, which existed for a while and then during the Harper years was repealed. This is essentially a section that says that you can't discriminate in your speech, and because it's a federal law, it will apply to telecommunications, which means the internet. And the wording of this version of it refers to hateful speech, which there's an attempt in the legislation to define that, and basically so that they can say, well, we've defined it. But if you read the definition, nobody can possibly know what it's going to mean when it's applied to future cases. It says, well, it's this, but not this. And the distinction between those two things is anybody's guess. So what you basically have is an open-ended prohibition on speaking in a way that might get you into trouble with the Human Rights Tribunal. And part of the fault of all this, I mean, obviously, it's the Trudeau Liberals for introducing the bill. And by the way, it's got a whole bunch of other bad ideas we can talk about as well. But part of the fault here, in addition to the government, is frankly the Supreme Court of Canada, who, as you will know, a number of years ago, along the way, has said that it's okay constitutionally to have prohibitions on speech on the grounds of hate. And in fact, some of the words in C-63 are taken from judgments of the Supreme Court of Canada saying, well, that's okay. So the people who have said about C-63, well, this has got to be unconstitutional. Now, maybe some parts of it will be, but this part's going to be a hard go, because essentially Supreme Court of Canada arguably has already said, wait, no, this is fine. So we're now in a situation where if this goes through, people will be able to complain about your online speech, make a complaint to the Human Rights Commission, the federal, the Canadian one. They can do so without a lawyer. It's easy to do. The commission and tribunal might decide that you don't get to even know who it is that's complaining about you. You have to hire your own lawyer. You pay them the fees. You have to take the time to defend yourself in this sort of Kafkaesque process. And at the end of the day, if you happen to lose, then you're going to end up owing the complainant and anybody else who you've allegedly harmed, even though they didn't complain, $20,000. And then to make matters worse, the government can sign up for an additional 50. So this is easy pickings for someone who wants to cause a lot of trouble, for the sort of the online trolls who want to get you into trouble. It's just a bad idea all around.
Yeah.
So let's just hope it manages to get defeated on the way to the way through.
It sort of applies the old adage, if you want more of a certain behavior, incentivize it. And it seems as though the interest here is to create a society of informers. But sure. the other bill that's going through, another bill, not another bill that's
Yes.
really concerning,
right.
is Bill 367, which was introduced last November by the Bloc Québécois. And this is the one that deals with really suppression of religious freedom on one view of the matter, which would make it offensive or actually punishable criminally. And just for quoting scripture, it would remove a protection, I believe, in Section 319 of the Criminal Code, which is a defense, an exemption to the charge of hate speech, if you were defending on the basis of scripture or some sort of religious document or theology, for example, the Bible or the Quran. So that bill seems to go hand in glove with C-63 and some of the other bills that this government has been passing aimed at suppressing speech. So I want to ask you a question that might seem obvious to some people, but I think needs an answer. Why is this government so interested in controlling our speech and what we can say, where we say it? Why are they so interested in that, in your view?
Well, it's a logical extension of a philosophy. I mean, let's call it an ideology if you want to, but it's a philosophy. It's the idea that it is the government's job to order things, to supervise, to manage, because the people are really not able to do that themselves. And because we, the aristocracy, if I can use that word, know better, then it's quite all right for us to decide what it is you can and cannot say. It's really a view, of course, based upon a profound kind of arrogance, but it's also not that unusual. I mean, governments throughout history have been based upon this idea, and we have lived under a managerial state for decades. And frankly, although it's bigger now than it ever has been, all the way along, it has still been based upon the same kind of idea, which is, look, there are those of us who really know what we're doing. We know how things ought to be. We don't really want you plebs deciding things for yourself. So more and more over time, we are going to supervise and direct and control and prohibit more and more and more, because you're really not doing things very well yourself. And if you take that idea to its logical extreme, you get exactly what we're getting now, which is, well, you really shouldn't say that. This C-63 is not that the so-called disinformation bill, but that's been discussed as well. The idea that you shouldn't be entitled to say things online which the government would classify as mis or disinformation. In other words, according to them, it might not be correct. In other words, they don't want to hear it. So we're in a very bad situation. But if I can raise another bill, I'm not sure how you feel about this one, but it's sort of on the same page, if I can put it that way. But its source is very different. It's a private member's bill that started in the Senate. And it's a bill that the Conservatives apparently have supported, at least until recently, and the Liberals have been against. And it's very odd that way, because it's juxtaposition to the other government bills. This is a bill that has as its stated purpose to prevent pornography from being available to minors,
right?
Which is a laudable purpose.
Mm-hmm.
But the mechanism that it wants to put in place is to require pornography sites to actually take your personal information in order to certify that you are above the age of 18. In other words, this is the taking of personal information of another kind for that purpose, and it is also a violation of your privacy and your anonymity and your freedom of speech, if you like. And yet, it's a bill that's being supported and opposed by opposite parties.
Mm-hmm.
And so this idea that there is a higher power that should be deciding what goes on is widely shared in different ways, and it gets expressed in different ways. And there's nothing worse, I think, on the table right now than C63. But even so, it's not a black and white thing. The real problem is that too many people who govern us think that their job is to supervise how we carry on.
Mm-hmm.
And
So
that applies to all the political stripes, I'm afraid.
Yeah. So what you're saying is that these bad ideas coming through with legislation, Bill C63 is not a one-course meal. There's actually a buffet being presented.
Yes, right, exactly so, yes.
So coming
That's right.
back to Rights Probe, when I
Yes.
asked you about Rights Probe, you said that part of its raison d'etre is to make people understand how the law actually works versus how they might think it works or how it should work.
Right.
And one of the best examples of that, that we're living through right now, seems to be the utter failure of the Charter to protect individual rights and freedoms in the way that we all expected it to prior to COVID-19. So why is this happening? Why is it that the Charter it seems to be unable to protect individual rights and freedoms in the face of really, really obvious government encroachment? That seems as though governments, I shouldn't say governments, political parties of all stripes, as you put it, are just being very brazen about designing bills that clearly offend protected charter rights. Why isn't the Charter protecting us, in your view?
It's a terrific question, and there are lots of reasons. Let me just talk about a couple. The first one is very basic, and that is that the Charter, unlike what I think a lot of people believe, the Charter is not the starting point for our legal system. The Charter is not the idea that our system is based upon. The Charter is an afterthought. The idea that our system is based upon, and there's more than one, of course, but one of them is legislative supremacy, meaning that legislatures can make any laws they want about anything. And sometimes people are shocked when they hear that because they think, well, there must be, there's just some things that they can't do. Not true. Not true. The default position in our legal system is legislatures can do anything they want. And then this Charter comes along and says, oh, but except not that. So it's just a gloss on the default position. But what that gloss means has been handed over to the courts. So we have now a combination of legislative supremacy, where Parliament and provincial legislatures can do anything they want, along with a good dose of judicial supremacy. And now the courts are deciding things, especially the Supreme Court of Canada, deciding things in a way that nobody else can have any say over. So they're interpreting the words of the Charter in the way that they want, and have been doing so since the Charter was brought in the 1980s. And in some cases, you can trace the ways in which certain of these sections start with their text, and if you just read the text, it would seem to mean a certain thing, and then you watch the jurisprudence over these past 40 years or so, and you think, wow, I mean, that's not what I would have thought, right? And so you have that phenomenon going on, but there's also a third thing, which is this: the Charter rights, not only do they tend to be very vague, so that the meaning has to be filled in by the court, but they're also very blunt, in the sense that in order to be violated, there has to be something sometimes pretty blatant. So let me give you an example. we had these vaccine passports.
Mm-hmm.
And that was a government program that was basically a government stipulation that in order to, go to a restaurant or go to a store or wherever, you had to have a vaccine. It's to be able to show at the door that you had a vaccine. And people said, oh, a violation of Section 7. Life, liberty, security of the person. You're not allowed to require me to be vaccinated. That's a violation of my security of the person, which encompasses some idea about informed consent and so on. Probably not so, because that's not actually a violation of your informed consent. And this is the story the government told from the beginning. They'd obviously worked it out.
Mm-hmm. Mm-hmm.
They worked it out so that it would essentially require you to get vaccinated without requiring you to get vaccinated.
Yeah.
So what they did was they slipped in between the cracks
Mm-hmm.
of the charter. And those cracks are pretty big.
Mm-hmm.
They went around to the back door. The administrative state took control of the situation, but not in a way that was blatant, in the sense that they said, you will get a vaccine or we will arrest you and throw you in prison. They never said that. That would have been a violation of Section 7. They did it a different way. They said, oh, you can decide for yourself whether or not to get vaccinated. And if you do decide to get vaccinated, then you will go to your doctor's office and give your informed consent. But if you don't decide to do that, well, then that's your decision. But you can't fly, you can't go here, you can't do this, but it's still your choice. And the charter proved not to be a good enough instrument to say, listen, that's essentially the same thing.
Mm-hmm.
And in effect, they said, no, the administrative state can do it this way so as to avoid charter liability, because after all, that's in the public good.
Mm-hmm. One very interesting analysis along these lines is from an Alberta historian named Michael Wagner, who wrote a great book. It's called Leaving God Behind. And one of the part of the thesis of the book is that what happened through the charter, and he believes this was intended by the framers of the charter, principally Pierre Elliott Trudeau, that it was a mechanism by which the legislative supremacy, which you talked about, which is sort of time honored, it's in the rocks in terms of English common law and parliamentary tradition. That was part of Canadian law, and theoretically at least still is. But it was a transference, sort of a silent transference of power from the legislatures to these courts, these unelected bodies, these people who are handpicked by government, especially by the prime minister, and who are appointed for life. And they now exert and exercise just incredible power, lawmaking power in our country, and in a lot of ways are shaping our country. One example is a recent case you probably saw, Bruce, where a justice of the Supreme Court said, well, no, actually the correct way to refer to a person who is a victim of a sexual assault is not woman, but person with a vagina. So they're actually changing the definition, just the basic definitions of who we are. So do you agree with that thesis, that part of the way the charter worked was to sort of transfer power from legislatures to courts in this way?
Oh, that has been the effect. No question about it. There are some things over which the court now has the final word. No questions asked. I mean, there's still Section 33, which is the stopgap for, if the court goes too far, the legislature can say, well, we're doing this anyway, and, to heck with it. But there are some things outside the charter, like Section 35 of the Constitution Act, which no legislature can touch. When the Supreme Court says this is what it means, then that's a done deal.
And those Indigenous rights you're talking about there, they just exploded. I mean,
Absolutely.
Arguably, Indigenous rights now have surpassed the enumerated rights in the Charter in importance, in legal importance in Canada. You could I think you could make a persuasive argument along those lines.
Yes, absolutely. But back to your thesis, which I agree with. But I have some misgivings in this sense. So I like to tell the story, the long story, right? You start with the king, and the king was a problem. This is way back in England, right? Around, throughout the centuries, the kings were problems because they had absolute power.
Right.
And over a very long, slow process, we took power away from the king and gave it to the legislatures, from the Magna Carta to the Civil Rights Act and so on.
Glorious Revolution. Yeah,
Glorious
for sure.
Revolution, all that stuff. And that was good, right? Because the legislatures, certainly today are elected, and the king was a tyrant, and the king's now just a figurehead. And so better for the legislature to have the power than the king. But the problem was that over time, legislatures showed that they could be tyrants too, right? And they've legislated an awful lot of bad stuff over the years, an awful lot of bad stuff, which is one of the reasons why the Americans created their Bill of Rights, saying, well, yeah, legislatures can do stuff, but here's the things they can't do. And so the Americans were the first ones to set this thing up, where a system where you've got a kind of judicial supremacy. The U.S. Supreme Court has much of the same role in their country as the Supreme Court of Canada does in ours, and we followed in the 80s with the charter. And so I agree with your criticism. The court has now got the power to decide the final word on a lot of questions that frankly, for my money, it has really made a mess of. But it's as close to the American model, which has worked better, at least at some times, than ours has. And so here's my criticism. From the beginning, when we started with the king, all we have done is moved power around from the king to the legislature, from the legislature to the court, and now from the court and the legislature to the administrative state. And for my money, I would like to suggest that was a mistake. The mistake that we made was not to just move it around. Instead, we should have taken it away. And then that leaves you with the question, well, if not that, then what? Where does power lie? If it lies nowhere, what does that mean? And that's a whole big, conversation. But it's the first step in that conversation is, hold on, none of these answers work. That we don't want the power with the king. We don't want absolute power with the legislature. We don't want the court deciding all the final answers. And we don't want the administrative state telling us what to do. So where do we go?
Okay, that's perfect. That's brilliant, because that's a perfect segue to the conversation I want to have with you. Because we said off the top, you're self-described classical liberal. And I wonder, you and I disagree slightly, or seem to disagree, and I want to go into this a little bit, because I think we can have a really interesting conversation about this. Classical liberalism, would you agree, fundamentally says that that we must protect primarily the rights of the individual. So you say where power lies, right? You said how it's moved around. Where should it go? Would you agree with me that classical liberalism holds that power should be directed at protecting the rights of the individual? Is that a fair starting point, or do I have that part wrong?
Essentially, sure. Yeah, essentially, yes. I think that's fair.
Yeah. And so a lot of our laws, let's take, for example, the writings of John Locke or Thomas Jefferson would be consistent with that way of thinking, right? When you think of the framing of the Declaration of Independence, for example.
Sure. Now, yes. I mean, essentially, those are among the people one might identify with this school of thought along the way. Now, of course, they have differences, and even those gentlemen and others still had in them somewhere the idea that there needed to be an elite class of people who would provide guidance and such. I mean, this is one of the ongoing debates about the framers of the U.S. Constitution, whether or not they were really protecting liberty or really setting up a situation of checks and balances where these competing elites would keep each other in check, but not getting rid of the idea of having an elite to lead along the way. But yeah, essentially, I think that's fair what you said. Yeah.
Do you think that what you just said then is part of the concept of classical liberalism, that we would still have, let's say, a ruling class? Would you say that that's a component of it?
Well, so here I would get part of the difficulty in these kinds of conversations is that it's easy to get tripped up by the labels.
Right.
And so, I don't mind being, and I describe myself this way as a classical liberal, but once I'm sort of in that camp, then
I'm not putting that
no,
label on you.
no.
I'm just trying to understand where you're
I
coming
own the
from.
label for sure.
Yeah.
But
Okay.
then I like to go, well, okay, so let's not worry too much about what the classical liberal literature might say in detail. I'll just tell you what I think.
Great.
For me, and for me, if you are being told what to do by an elite, in a way that you have no control over, then you're not really free.
Yes.
Right. And so there's through within the classical liberal literature, as it has come to be known, there's some tension and some inconsistencies and so on, as there is in schools of thought of other kinds. But so I don't like to rely too literally on what the giants have said, because you can see that what they have said is, it doesn't always completely hold together.
Mm-hmm, mm-hmm. We're always kind of sort of trying to approximate the forms, right?
Right.
Yeah. No, that makes sense. So where I was getting at, in terms of, let's say, critiquing classical liberalism,
right?
Just for the sake of discussion,
okay,
is that if individual liberty is taken too far,
right,
it does start to become literally self-destructive. Using the example of let's talk about MAID, right?
Okay, sure.
I have the right to murder myself. Let's talk about transgenderism, mutilation of the body, the taking of drugs that will permanently change my body chemistry.
Let's try those two. Those are two good examples.
Yeah,
those are two good examples.
So let's talk about
right?
those. Are those examples of where the rights of the individual, if exalted, would go too far and actually begin to descend into nihilism? Is my question. What do you think about that?
So let's take MAID. So there are. So I think one of the misconceptions about the MAID debate is that there are two sides, and there are not. There are three.
Okay.
The classical liberal, or what I would call the classical liberal version of MAID, is missing. The classical liberal version of MAID is not the one we have. That's a terrible version. Mm-hmm. It's a progressive, woke, murderous version, mm-hmm. in the sense that it is the state who is providing the service. It's the state who is promoting the service. It's the state who is approving of the service, and the state who wants you to die. I mean, that's not freedom.
And harvest your organs in the meanwhile.
Sure, right. This is not the way things should be. Mm-hmm. The conservative, I'm going to use that label. I mean, I know conservatives are as varied as classical liberals are, probably even more. But let's just, for the sake of the argument, let's call it a conservative point of view, which is that suicide is wrong. Mm-hmm. And whether or not you're doing it to yourself or your doctor's doing it to you, this is not a thing that we should do.
Right.
And for that reason, it should be prohibited.
Mm-hmm.
And the classical liberal version of this is none of your business. Mm-hmm. It's not the state's business. It's not my priest's business. It's not my neighbor's business. It's my business. I'm allowed to do what I want. If I can find a doctor, not through the state, not through Medicare, but if I can find a doctor who will contract with me to kill me in the way that I request with my consent, then it's nobody's business but me and him. Mm-hmm. That's my version of things, and that mm-hmm. version I approve of. That's not because I approve of suicide. I might think that's not a great idea. Mm-hmm. Doesn't matter. It's not my business.
So it's sort of this. Yeah, go ahead. Sorry.
Yeah. So no, but one of the things that the classical liberals do, that the conservatives do not do, is say, look, I have a view about these things, but my view about what the law should be is different. Mm-hmm. My preference is X. The law should say Y, because I got no business imposing my views on things on other people. The conservatives don't do that. They say,
Mm.
look, I know what's right and wrong, and that's what the law should be.
Right.
Right.
So,
And
so you're saying, just to paraphrase, it's sort of this John Stuart Millian idea of the right of your nose, or my fist ends where your nose begins, sort of idea.
Well,
that's
a very important idea, but I think it's a bit of a different idea.
Okay.
And that's the idea that even for people who believe in freedom, we acknowledge that freedom doesn't mean that you can go around attacking people.
Right.
You can't go punching people in the face, because
Mhm.
that's a violation of their freedom.
Mhm.
If we are all free, it's universal freedom. And that means you are free from the coercion and violence of other people, as well as the state.
Right.
Okay. So this state of freedom doesn't mean you can do anything you want, because other people have rights too. No, but in the maid situation,
Mhm.
nobody else's face is involved. Right. So
Fair enough.
if you go into your own private space with your own private doctor and your own private life, and you want to do this own private thing, and you've fully consented and you're totally competent, then there's nobody else's face is involved.
Well, let me present the counter argument.
Okay.
So let's say, for example, Sir Roger Scruton, the late Sir Roger Scruton, wrote that good things are easily destroyed but not easily created.
Right.
And I think we can take as a given that a human life is a good thing. The Ted Bundys of the world and Adolf Hitler's aside, as a general proposition, human life is a good thing. It's not easily created, and it's easily destroyed. So as a person living in society, do I have an interest in other people not killing themselves? Is that a good that we would want to promote living in society? And so conservatives would say, as and again, to use Scruton's example, he phrased it in terms of, what does a conservative do? Well, we conserve. What do we conserve? He described it as beauty being a broad concept of all the things that we would hold dear as a society, the things that Mr. Trudeau thinks don't exist in Canada. But I mean, the kinds of things, if I were in your living room and I saw, pictures of your family, mementos, academic awards that you've won, things like that, works of art. If I saw your musical collection, all the things that you thought were worth preserving, that is, to use a Socratic term, is, the approximation of the good that we want to preserve as a society. And if we don't do that, there's great peril in that. There's a great danger in that. And so to put this sort of, I don't want to set classical liberalism or conservative in opposition, but I'm saying, I think what I'm seeing right now, and this is kind of what I want to get your take on.
Yeah.
Do you see a kind of a tension here where we're seeing the individual liberty reaching a point where it's in danger of maybe tearing down some of the things that Scruton and others would describe as beautiful, that we actually want to preserve? And are we in danger of destroying the fabric of a society that we've all enjoyed, that's been made us more free, more prosperous than anyone in history, by exalting individual liberty in the way that you were describing? Or do I have that wrong? I'm interested.
No, you're quite right. This is the tension. This is the elephant in the room between the classical liberals and the conservatives, right? So both of them don't like what they see now. Yeah, they're both against all the woke crap, all the progressivism. We're of a mind that where we're at now is a bad place and we're going down the wrong road. But the diagnosis of the reasons are quite different. Right. So the conservative would say, as you just expressed, the problem is too much freedom.
Right.
And the classical liberal would say, not enough freedom. Right. That's right. So for me, the question, in a sense, comes down to, so these two kinds of questions are easily mixed up. And the two kinds of questions are, what should we do as human beings? How should we behave? What should we value? how do we discipline ourselves? How do we be free from our animal instincts? Okay. There's another category of question, which is, what should the government do?
Right.
Right? When the government sees us behaving in a way that the government does not approve of, what should the government do? And one of the possible answers is, well, the government should use its power to enforce virtuous behavior.
Right.
Here's the problem.
Who defines virtue?
That's what it's doing now.
Yeah. Bill C-63. Yeah.
Bill C-63.
Yeah.
Now, we might disagree with the virtues they've chosen, but we don't get to decide that because it's the government. So it has the power to decide what virtues it wants to enforce. So the choice for me is very stark.
Yeah.
Either people are allowed to decide for themselves or the government decides for them. And you do not want the government deciding that for you.
So you're saying it's a lesser of two evils then. Yeah.
I'm not dissing the kinds of virtues that you're talking about. I'm just saying you don't get there through government. You know, you get there another way. You get there through civilization itself. You get there through people, through churches, through communities, through families, through associations with other human beings who will bring you up and make you the human being you're supposed to be. Do not rely on the government for that. That is a recipe for disaster.
Yeah, I totally agree with that. But I'm interested. That brings me to this question. So if we think of this sort of like like a Venn diagram.
Yeah.
And there's this intersection of, let's say, where classical liberals and conservatives, for example, are crossing over. It used to seem to me that the area where we agreed, if we could shade that in the diagram, was pretty big, right? So there wasn't a lot of there wasn't a lot of differences on like core values as between, let's say, conservatives and classical liberals. Now it seems that everything has the whole political spectrum has been pulled apart, and so the shaded part where there's convergence, it seems to be almost not very small or non-existent. And I'm curious to know what you think about, if you agree with that. And second part is why it's happening. Number three, how do we fix it? Like, how do we get back to a society where, whatever our religious or private connections, we sort of see ourselves as a collective inheritors of things that are excellent and rare. Like, how do we get back there?
Yeah, I'm not sure that the appearance of congruence between the two groups has always been as large as it appears. So if you go back to certain moments in history, I mean, those two basic sets of ideas were the two that were in battle.
Right.
You had liberals who were actually liberal, and conservatives who were conservative, and the tension was between, well, do we enforce these behavioral rules or do we let people do what they want? Those were the two choices, and there was no such thing as woke, no such thing as progressivism. I mean, progressivism's been around for a long time, but it's become something else.
Right.
And when people, especially conservatives, when they think liberals, they think, oh, liberals are progressives, but liberals are woke. I mean, sure, call yourself a classical liberal if you want to, but liberals are the problem. So I don't care what kind of liberal you are, you're on that side. Well, no. This is a different thing altogether. So that area in the Venn diagram you're speaking of, I'm not sure was as large as you might think, because classical liberals, I would like to think, again, all kinds of variations, but I would like to think would dispute the primary conservative conviction, which is that all these things are group things, they're community things that other people have interests in. And the classical liberal position, or at least my position, would be, no, this is my business. This is my life, my business. I will decide, and I don't care what you think. Now, I don't mean I don't care what you think literally, but I mean in terms of the rules, in terms of forcing me to do or not to do something. I don't want you part of that conversation. So in that respect, there's a huge distance between classical liberals and conservatives. And one of the problems in this fight going forward against the woke that we're in on together is that the classical liberals and conservatives don't trust each other for this reason, right? The classical liberals do not want to be under the thumb of conservatives any more than they want to be under the thumb of the woke.
Right. Yeah.
And the conservatives don't want the classical liberals to go off and do whatever the hell they want any more than they want all this woke nonsense. Right? The conservatives want order. And the classical liberals want peaceful chaos. As long as it's, for a classical liberal, as long as it's peaceful, there's no violence, anything is fine. For a conservative, that is poison.
Right.
And we have to find a way to reconcile.
So you would say that maybe the antidote to the chaos you're describing, that is what we're living through right now, would be a return to a renaissance of classical liberalism, classical liberal thought, in a pure sense that you're talking about, where the individual rights of citizens, of people, are protected, and in a society in which individuals are not permitted to do harm to others, but they're permitted to live out their lives, to be self-determinative.
Let's be careful.
Right?
So people say it that way. I'm sorry to interrupt, but
go ahead.
But so it's often referred to as the harm principle.
Right.
That's not quite right for me, because there's all kinds of things you're allowed to do that cause people harm. I mean, you're allowed to compete with them, right? You're allowed to commercially compete with another business and put them out of business if you do better than they do worse.
You can offend them by something you say, at least for now.
Sure, absolutely. So it's not the harm, it's the force. I mean, you're not allowed to coerce somebody with violence or the threat of violence, essentially, right? So, and sometimes that causes harm, but sometimes it doesn't. I mean, it's still a wrong if you touch people without their consent and cause them no harm. It's still a wrong because you've used force, right?
Yeah.
So anyway, sorry, I didn't want to interrupt. Go ahead.
No, I was that was perfect what you just did, because I was trying to paraphrase what you were saying. But I guess my point is, do you see that as, let's say, the way forward? Is that the antidote to the chaos that we're living through right now? Is to sort of get back to that, or get to a place where individual rights and freedoms are respected and protected in society, in the way that you understand it, in the classical liberal sense?
Yes.
Is that your sense of an antidote?
Absolutely. And let me just describe that as carefully as I can, so that the conservatives among us might see it in its best light. So what this means is that the government shouldn't be able to tell you what to do other than preventing you from interfering with other people. Okay? What that does not mean is that we should live our lives as isolated atoms. It means that you should interact with everybody else in your life, communities and families and churches and what you have you. The distinction is not individual and collective even. It's voluntary and involuntary. All the classical liberals want is a voluntary society. That means you can interact with anybody you want and come to an understanding. If you want to join a religion and the religion has rules and you want to abide by those rules, then go for it, because that's great, because you are all coming together voluntarily and deciding what your moral code is. That is great. What we don't want is the government to come in and say, this is our moral code, this is what it's going to be. Right? So I don't like the individual collective distinction, because it gets interpreted in the wrong way. I prefer voluntary, involuntary. And when I point this out to conservatives and say, look, you're not the collective people, you're the coercion people. You are saying you will do it our way or else.
Right.
And then they back off and say, well, that's not really what I mean.
Mm-hmm.
And that's good. Right.
That's good. That is very good. Brilliant conversation. I'm so grateful. You've clarified so many things in my mind, and and I hope people watching this or listening to this will see that my guest and I had a very civil conversation. We disagree about some things, and hopefully that was clear. But I hope that you saw that we listened to each other and we expressed each other. And at certain times, we risked perhaps offending each other, but at all times we were civil. And this is how we have conversations in society. These are the conversations that we need to be free to have. So hopefully, if you take nothing else out of this conversation, I hope you take much more, because a lot of what our guest has said was just really brilliant stuff. But if you take nothing else, I hope that you saw that we can have civil conversations, even where we come in and we disagree about some things. I listened to Bruce today and I learned a lot more about what he thinks. And it's going to cause me now to go back and question some of the ideas that I had, some of the things that I thought were true. And this is how we learn. This is how we exist in a free and democratic society. So hopefully, if we've done this right, this has been a really good example of that. And I thank our guests so much for this.
Before you go on, I just want to say, no, I was just going to say, very well said. Very well said.
Thank you.
Thank you for that.
Thank you. And Bruce, we're going to go to our reading list, and I'm going to say I have to admonish you because I couldn't find a book that you've written yet. What's going on?
Yeah.
You must start writing books.
Yes. Right. Well, I wrote one a while back, but it's a rather academic piece, so I'm not even going to. Well, I think people might find it not hard going in the it's a very thin book, relatively speaking. It's called Ecologic, ECOLAWGIC.
Well, tell us about it. Great.
It's an attempt to describe governance using two analogies. Those two analogies are ecosystems and markets, basically making the case that ecosystems and markets are really the same dynamic. Mm-hmm. So, I mean, if people are interested, then by all means, but it's not it's probably not the kind of book you had in mind as a recommendation.
No, we have all kinds of books on here. And where would people find that book then if they wanted to order?
Well, the best place to find it, it's available both in printed form, but also in PDF. I've posted it also on the SSRN website. I will send you the link so people can, if they want to.
We'll provide the link.
If they want to, people can go and find a PDF for no charge. They can access it for free, and they can wander through it at their leisure.
I dare say that many of the people listening to you today will want to get that book. I certainly am going to order it. The other book I was going to talk about today, before I turn back to you, Bruce, to give you the final word, is from someone who I know both of us admire, possibly the greatest living public intellectual, Dr. Thomas Sowell. There's written so many wonderful books, but this one is called Intellectuals and Society. It's not his most recent book. He has another one out that's actually quite good. I just finished reading it. But this book offers a withering and clear-eyed critique about, but not for intellectuals, that explores their impact on public opinion, policy, and society at large. And of course, our guest was talking about this somewhat today in different contexts, but always talking about, this idea that intellectuals have this influence, and it's not only greater than in previous eras, but also takes a very different form from that envisioned by those like Machiavelli and others who have wanted to directly influence rulers. But what we have now, according to Dr. Sowell, is we have intellectuals in society. Not only he says in this book he examines the track record of intellectuals and things that they have advocated. Let's take COVID-19, for example, but also analyzes the incentives and constraints under which their views and visions have emerged. And this has really changed the whole landscape. Another example of this, of course, is climate science, quote unquote climate science. Social justice is another one. And so this book is wonderful, like all of his books are, but I find, Bruce, that it cuts across a lot of the different dimensions of how intellectuals are really infecting society with their ideas, and in a lot of ways are determining the rules of the conversation. I mean, some of the legislation that we've been talking about, this heinous legislation, is really coming out of leftist think tanks, like things
Sure.
like hate speech. And so Souls just does such a great job of identifying all these things. The next book that I'm going to mention is actually free. You can get this one for free. It's a book I know our guest is familiar with. It's actually more of a pamphlet, but it's called The Law by Frederick Bastiat. And this book was written a long time ago. It was written by Bastiat, was an economist, statesman, and member of the French Assembly. His writing was during the he's got it there. The writing was during the time of the Revolution of 1848, when France was moving towards socialism. And, it puts into context so many of the ideas that have flowered during our modern era, the woke. I don't know if you agree with this, Bruce, but so much of it seems to find its origins in the French Revolution. So much of even the word the left, comes out of the French Revolution. Hopefully things don't get as bad here as they did in the French Revolution. But I mean, there are so many parallels. A lot of the ideas that we're dealing. Honestly, you could look at just Marxism in a real sense. Socialism comes out of the French Revolution, and Bastiat was so much in tune and is able to explain really so far ahead of his time, like these timeless ideas. And so this is a
and
great
I really
book to understand this.
respect how he's able to write in such an efficient way. Look how thick it is.
Yeah.
It's a very easy read. So recommended.
Yeah. So back to you, Bruce. And I know you're obviously you've got a lot of books on your brain, but in terms of people understanding some of the things you've been talking about today, are there any that you would recommend?
Well, I'm going to suggest one that's written by a friend of mine who is a professor of law in Australia. He's a Canadian originally, but he has been a professor in Australia for quite a number of years. And again, it's a bit of an academic legal book, so some people might find it hard going if that's not the area that you're acquainted with, but it's called The Age of Foolishness, A Doubter's Guide to Constitutionalism in a Modern Democracy, and by James Allen. Looks like that.
Oh, okay, yeah.
He goes through a lot of the accepted premises of the way our legal system works, and then takes them one at a time and says, well, but that doesn't really make sense, does it? And so it's a bit of a mind-bending book. Especially if you're a lawyer and you've sort of absorbed certain tenets as the way things are supposed to be and must be, this will challenge you.
Well, that's wonderful.
Yep.
Any other selections, or
this is a book of essays by people who, and there were fortunately there were a good number of us, you included, Leighton, but essays by people who spoke out against the COVID regime. They're called Canary in a COVID World. How propaganda and censorship changed our world. Yeah. And that one's available on Amazon.
That is a wonderful book. It's a book of essays. And one of the things I really enjoy about that book is the variety.
Yes.
Such a broad cross-section of people who are scientists or legal scholars like yourself, psychologists. There's something for everybody in that book. So I have it on my shelf, and I strongly recommend it. Well, Bruce, we want to thank you again for being with us today. I always enjoy our conversations whenever I have the opportunity to get together with you on Zoom calls or whatever the situation. I always come away, learning more and knowing more about the law and about the things that are so much impacting us here in Canada than I did before. And this is no exception. So grateful for your time and for all the work that you're doing on behalf of all Canadians. So thank you very much for being our special guest here today.
It's my pleasure. It's always a great pleasure to speak with you, Leighton. So thank you for the invitation, and carry on with your great work.
Thank you.